Hi, I'm Ken Mann with Equity Partners HG. Today I'm here with Peter Barrett, a partner at Kutak Rock in Richmond, Virginia. Peter represents all the various parties in Chapter 11s, reorganizations, turnarounds, and mergers and acquisitions, and has particular expertise in franchise businesses. So today we're going to talk about what is unique in a turnaround or a bankruptcy if it happens to be a franchise case. So obviously the first one, Peter, that jumps out to me is there's this entity called the franchisor.
That is really the one thing that makes a franchise case unique is the presence of the franchisor and that additional party in the room that needs to be dealt with in negotiations. And the franchisor has a tremendous amount of power, not just through the franchise agreement, but with the control of the brand. And so whether it be hotels, restaurants, any of the type of typical franchise business, that franchisor is really an important player in the restructuring of the company.
If you're trying to do a sale, for example, the issue of the assignment or the assumption of the franchise agreement, how does that usually play out? Where's the power there?
The power that the franchisor has is a couple things. One, as a creditor, usually you have royalties that have not been paid. You may have advertising costs that have not been reimbursed. And so they are the traditional creditor. Some franchisors, although fewer this day and age, actually finance their franchisees. That's more of a rarity these days, but that does happen. But what the situation that you're talking about is where you have the assignment of a franchise agreement. Outside of bankruptcy, it's completely governed by the franchise agreement itself, which will have an assignment and more typically an anti-assignment provision in there. Inside of bankruptcy, though, you're governed by 11 U.S.C. 365, the executory contract, and unexpired leases provision. And those provisions, as they apply to franchise agreement, bring up some complex legal issues because franchise agreements are not just an executory contract, they also involve a license, an ability to use the marks, the famous M for McDonald's.
Most franchises that I run across are retail in nature, so there's pretty much always a real estate component. Talk about the issues that you see there.
The typical franchise, as I mentioned before, is a hotel, is a restaurant. And in most situations, those franchise locations are going to be leased. So that's an important thing when you walk into a restructuring, is determining what assets are there and what is being restructured. And when the assets involve a leasehold interest as opposed to an ownership interest in real property, the value is lower. And I think that impacts what can be done in a restructuring.
Sounds like a restructuring in a franchise case is going to be really difficult to do without the benefits of Chapter 11.
Restructuring outside of bankruptcy is difficult. A restructuring inside of bankruptcy, of course, brings its own unique challenges. But a restructuring outside of bankruptcy is difficult because you don't have the leverage that you have in the bankruptcy case through the bankruptcy code, the ability to reject a franchise agreement, the ability to assume and assign leases. But outside of bankruptcy, you do have one thing going for you in a franchise case that you don't have in other cases, and that is that the franchisor exists. And that franchisor can be your enemy in the fact that you owe them money and they're going to control the brand. But they're also the friend because they control the brand, and it never makes a brand look good to have it fail. And so they always have a vested interest in either success or a quiet and clean failure.
Okay, that makes sense. If the likely outcome of a restructuring is a sale, it would seem then as soon as possible you would want all prospective bidders to engage in the approval process so that hopefully by the time you got to an auction, a going concern auction, you would have bidders that were pre-approved. Is that likely?
Having bidders pre-approved is a perfect world. And in all restructuring cases, from smaller ones to larger ones, generally the more dollars involved, the level of sophistication increases. Franchise cases can involve smaller dollars. You can have a multi-unit franchise case that's only a an 8-figure restructuring. And I say only an 8-figure, obviously that's a meaningful amount of money to the people involved with it, but it may not bring the level of sophistication that somebody is going to automatically qualify for the franchise. And there are bidders at auctions that we've certainly experienced, that I know that you've certainly experienced, that come in and bid for items without having the approval of the franchisor. And that's a recipe for, if not disaster, a very, very tumultuous sale and approval process.
My advice to those buyers is make sure you get competent legal counsel early in the process, but they sometimes resist that.
My advice is always to have competent legal counsel by your side at all times. But
it's funny that you would say that. So let's talk about the vendors. We've talked about the franchisor and some of the issues around that. What's different in a franchise case with its vendors, its traditional payables?
One way where it is different is that you will have pre-approved vendors. So if you have a fast food franchise, a quick service restaurant, you are not going to just be able to source your chicken anywhere. You are going to have pre-approved vendor, and if you get behind with that vendor, you can't just go to chicken manufacturer number 2 because
Right.
they have certain requirements. They have to be a certain size, they have to be a certain quality, and so you have that. So you really do have a critical vendors. Then the other thing, and this comes up in restaurant franchises, is you have the PACA. It's the Perishable Agricultural Commodities Act, which is basically you are holding funds for those vendors in trust. So instead of having money that you could use for the bankruptcy or would become part of the bankruptcy case, this sum of money for those perishable agricultural items is actually not part of the bankruptcy. And that's something in the pre-bankruptcy planning that has to be taken into account is, do I have PACA claims and do I have funds to set aside for that? And 2, do I have critical vendor claims? Do I have the place where I'm going to get the franchise approved straws, cups, plates? And are they in good stead so that I can keep operating after a Chapter 11's filed?
Whether you're the franchisor or the franchisee, you need to get counsel involved that has experience in that. We want to thank you for sharing your wisdom on the topic and appreciate you being here today.
It's my pleasure. Thank you.
Thank you.